thank you very much for the invitation to come to a Fly High Fika seminar. It's going to be exciting to talk about my favorite topic area, law and IT. Jenna just asked me to say a few more words about myself, and it's well, my profile is very conventional in that I work as a researcher, as a teacher, and I've also done quite a lot of work for the Swedish government as responsible for public inquiries in the field of, well, where there are interplay between law and IT. And I worked nationally as well as internationally. We have a quite close cooperation with the UK and Australia and Austria. I mean, we've become international over the years, no doubt. Law, well, what I'm going to do is I will introduce you to law and informatics within a DataLEASH approach, and DataLEASH is a project within the Digital Futures. May I just ask, how many participants are there right now? I can see 4 or 3 people. How many people? Is that it?
14 altogether, says the below. If you look on your screen, it says participants, and there's
yeah, but it's not.
You won't be seeing them all.
No.
But with you, we are 14 right now.
Super, thank you very much. So I'll divide my talk into 2 parts. The first part is devoted to the topic area or the interdisciplinary field of law and IT, including multidisciplinary aspects as well. And then, to the extent that time allows, I have approximately 40 minutes at my disposal before we'll have a Q&A session, also depending on what comes up in the chat. And the first part, the overall view of law and informatics, and the other part, to the extent time allows, I will share with you parts of a presentation that I gave last week when we had the 15th Nordic Conference of Law and IT, just to illustrate how we work within the DataLEASH in a broader context. So that's my plan. Sometimes we say, so in terms of in an introduction, that we talk about law and IT, but it is actually informatics from a computer system point of view. I would like to emphasize that law definitely is the basis for what we do research in, but we do our excursions and we are really interested in the interplay between law and informatics. That's where it happens. It's a topic area that was established at Stockholm University in 1968, and that was just the beginning. And well, there's no doubt so that law and IT, in Swedish rättsinformatik, in German Rechtsinformatik, it has become more and more topical. I was a bit, well, maybe some of you remember the Mac computer that I couldn't resist copying into this slide. We've been interested in the law and IT area for quite some time. So, okay, law and informatics, an interdisciplinary area that actually has 2 major fields of interest. One is what we refer to in terms of substantive ICT law, and the other one we refer to as legal system management. Please excuse me when I mix IT, information technology, and ICT, information communications technologies. I mix those acronyms. So within our research field, we both work with substantive IT law issues, by which is meant how to, well, legal issues that have to do with how you interpret and apply legal rules and regulations in a digital environment. So that's really the conventional legal aspects. But then what might be even more interesting, I would say personally, is what we refer to as legal system management. More precisely, how you can, should, ought to integrate, embed legal aspects into different kinds of system digital environments. Um, and the very interesting um, results, or what calls for attention, is in the interaction. Let's say, for instance, that you are considering whether a certain document could be a government bill, it could be contract laws, or any kind of document. And the question arises, is it possible to fulfill a formal requirement of a signature? Is that formally required? And also, what are the implications? So such a question is very difficult, actually impossible to give a prompt reply to. But you need to, in order to give a correct answer, you need to know both the substantive law rules, nowadays emanating to a great extent from the European Union, but you also need to have some kind of understanding of different technological approaches to fulfill a signature in the digital environment, in terms of public key infrastructure solutions, cryptographic solutions, of course, public key, private keys, all those um, approaches need to be framed in a legal environment. So it's not good enough to say, from the legislative point of view, that something is approved of, or permitted, or the other way around. You need to study both the rules and regulations and the technological approach or solutions, or what is available as tools. Law and IT, law and informatics, is quite a comprehensive field, covering a lot, and it's therefore quite important to find some critical factors to focus on, to play an emphasis on in your studies and analysis. And one approach to have a better understanding of this area is to pinpoint at least 4 major critical factors. One has to do with ICT in itself becoming a subject to regulation. And just to give you an example, I will use data protection as an example to quite a large extent today. When the lawmaker, broadly speaking, regulate, for instance, in terms of legal definitions, what is to be understood as a controller in the data protection environment? How do the lawmaker in the GDPR, General Data Protection Regulation, define personal data? What is meant by consent in the digital context? So that's just one example of when ICT has become subject to regulation, and by that also giving rise to issues of interpretation and application. And this is quite quite a common view, or quite a common component within our research field. Of more personal, I would say, much more interesting is when we study and do research in the context of when ICT function as a legally oriented steering mechanism beyond the metaphor of the tool ICT, computers, merely being a tool. In our research field, we have an understanding of ICT being much more important in terms of steering mechanisms. And it doesn't have to be AI, it could be conventional automated procedures during which legal language is being transformed into algorithms that are coded by computers. And this could be harmless, but it could also be very important in terms of designing legal solutions at early stages of system design. When we study law and IT, we are in particular interested in when the technologies provide a steering mechanism, and we engage quite heavily in the algorithmic discussions on how to compare deterministic algorithms at the one hand, and the more dynamic, the black box oriented algorithms that, well, and then we enter into machine learning, etc. So what we study in the field of law and IT is ICT becoming subject to regulation, and also when ICT function as a steering mechanism, and also as a lever for internationalization of law. I mean, law used to be very national. I mean, if you wanted to, as a student, you wanted to stay at home and don't go cross-border in any way, then law was the perfect topic area to study. But what we see now is an immense internationalization of law, giving rise to very fundamental jurisdictional issues when about what happened when and how, by whom. And fourth, one should not neglect the fact that lawyers, to a growing extent, work in a digital environment, virtual client rooms, for instance, and legal tech solutions for client management, knowledge management approaches, etc. So ICT definitely has changed the way lawyers work, and there are authors saying, Richard Susskind, for instance, he wrote a book about the end of lawyers. But then again, there are the rise of judges. So, well, it's a dynamic field, and it reflects development in society on the whole. A major theme in the area of law and IT is no doubt legal automation. And of course, our fundamental approach is that technology in itself is neither good or bad as such. It's how we develop it, how we use and implement a legal automation. And I just want to briefly say that there have been studies about legal implications of wholly or partly automated procedures for decades. There's a very strong tradition in Germany for that, and discussions about whether it's at all possible to let a machine make legally binding decisions. And the answer has been yes, but not all the time and not in any kind of way. But so legal automation, interpreted very broadly as legal issues related to automation, is a central theme within the area of law and IT. Some challenges of legal automation, and I'm convinced that this is not typical just for the legal field, law and IT. I know that within many of course, within many disciplines, IT give rise to quite delicate questions and issues. And from a legal point of view, we are interested in the how machine intervention coexists with human intervention, and also how to differentiate decision support systems as opposed to decision making systems, and how to distinguish and why at all make a difference between static deterministic algorithms on the one hand and self-learning ones on the other. And furthermore, the legal conditions for designing systems supporting automated decision-making differ quite a lot between what goes on in the public sector as opposed to the private sector, because there are so many more legal frameworks, I would say, when you computerize or digitalize, the public sector as opposed to the private. And then also one should not neglect the fact that the way in which data are being handled, um, case law, decided court cases, for instance, differ a lot, but not as much as before, I would say, but between different legal systems that could be labeled as common law systems versus the civil law systems. So there are quite a lot of challenges at a very general level that needs to be illuminated and investigated into. And now I have two more slides, and maybe you will be shall I say, a bit upset, because now from a legal point of view, I am entering definitely your areas. But from a legal point of view, it is important to investigate into, to dive into some legal relevant, what I named IT features, and being very well aware that you on the one hand, you cannot really make this kind of lists, but then again, it is relevant because the kind of computerization, the kind of design, development of software using what may be referred to as conventional EDP, electronic data processing, has legal implications. I just touched upon it before, and what I'd like to say is that legal text sometimes appear to be very easy to digitalize because there is a seeming logic that characterize rules and regulations. But then again, when you start programming laws, you will understand, you will be aware that this is not as easy as it looks like, because there are vague concepts and there are ambiguous rules that somehow must be interpreted, and then question mark, by whom? Who has the right to computerize, digitalize, program um, um, legal texts of different kinds? That varies according to, with reference to public-private sector, the kind of application, etc. But conventional software development do give rise to issues related to digitalization of programs and the design of algorithms that can be that then are coded and run by computers. When it comes to database technologies, we enter into the whole world of information retrieval and relevance ranking systems and issues that refer to recall, precision, coverage. And for instance, how do you, from a legal point of view, how do you separate uh, relevant cases in a certain situation from non-relevant cases, for instance? What is relevance in a legal point of view? Can you state, can you claim that uh, a court case either is relevant or not at all relevant, or is it more or less relevant? And who has the authority to say that this court case is irrelevant when interpreting another one? So the use of information systems, database technologies do give rise to legal issues of quite a complicated kind. Then also information standards. As quite some time ago, I worked with SGML. That was the forerunner of XML. When you use information standards for within the legal domain for accomplishing more structured documents, facilitating information security, information retrieval, etc. And by way of designing schemas and you get involved in legal information in a way that also gives rise to issues that have implications when it comes to the rule of law, legal safety. And you can go on with uh, telecommunications, internet service providers, the way protocols of different kinds are managed. And just to give you a bit more, a list uh, of what we are currently quite engaged into, it's AI, uh, and AI in particular when it comes to decision making, machine learning, And honestly, one of the tricky bits with technological development today is no doubt the self-learning algorithms that cannot be explained to the extent that the lawmaker requires. For instance, within the framework of the GDPR, when a controller, under certain circumstances, are expected to be able to explain, provide meaningful information about the logic behind a certain automated individual decision, which is a true challenge for the legal domain, for legal systems. Cloud computing solutions, I'm not going to argue that it is or is not any new technologies, but definitely new, relatively speaking, business model. And it is quite challenging because, well, major aspects of this business model is, of course, that you do not necessarily beforehand know what personal data will be processed where, by whom, and how, for how long. And that is definitely in contrast to many data protection principles. So here we also have to dig in. And social media is also does also give rights to issues about who is the controller, and within the public sector, for instance, is it possible for a public agency, a possible and legally valid for a public agency to enter into contract with a complete different jurisdiction and different legal rules being applicable? Is it possible for public agencies to enter into that commercial environment? That's a question mark, and there is an ongoing debate and legislative activities trying to figure out under what circumstances personal data can be processed in third countries that's outside European Union, etc. So from a legal point of view, what I refer to as IT features is, I'll give rights to legal issues that is important from the point of view of the rule of law. And I would also like to bring in issues concerning trust and ethical aspects, and of course also business life. So it's not just doing these kind of laboratory approaches for the fun of it, although it is fun, but is also from the point of view of certain fundamental values in a democratic society, important to follow the technological development. If you are interested, please have a look at what we're doing in DataLEASH, which is part of the Digital Futures program. And I represent a lawyer in the project group, and you see the web address at the bottom of this slide. And what I see that we do in the project is, for instance, design, legal design work. So we try to combine data protection principles with data protection by design and by default. And GDPR, this regulation, is indeed interesting because it opens up for letting law play a proactive role instead of the conventional reactive mechanism when things have already gone wrong and given rise to quite costly solutions, if it is at all possible to make correct again. So I thought I would just use a couple of more minutes showing you the kind of, well, illustrating the kind of questions that we engage into within the area law and IT, and week, we had our Nordic conference here in Stockholm, and I was invited. I mean, this is my institute, not mine, but together with my colleagues, of course. But I was invited to give a talk about a conceptual approach to AI and data protection. And what I did with the overall ambition to get a better grip on GDPR was to test to show that there is a need to supplement the conventional, more or less sequential checklist approach that when you, as a lawyer or legal scholar, approach a certain legal framework, you start by checking whether is the regulation, is it applicable, exemptions, what legal definitions, and different kinds of processing. Very procedure-oriented approach, a sequential approach to data protection. And what I tried to do was to just as a discussion point, showing how you could, instead of the sequential approach, use and discuss different concepts. And but then as soon as you leave the very comfortable legal domain, it becomes much more complicated. And this is also an illustration how difficult it can be to be active in an interdisciplinary research environment. Because when I start talking about conceptual approach, then maybe some of you in the audience start thinking about vocabularies, ontologies, decision trees, and conceptual modeling, etc. My my view is that in spite of not being in command of all these terms, terminologies, decision trees, etc., it is important that lawyers enter into the discussions that otherwise will be possibly too technical, and lawyers will be not sufficiently knowledgeable about these kind of concepts. And I think it's important because you see so many misunderstandings in the society, in the data protection society, and misunderstandings. For instance, it's not obvious from a linguistic point of view that the notion of anonymity, anonymization of personal data, is in fact equivalent to excluding GDPR from its applicable scope, as opposed to pseudonymization, because if you pseudonymize your data, it's still personal data from a legal point of view. And there are lots of different kind of concepts that have legal implications. And here you just need to be, from a legal point of view, brave entering into these technical terms that you otherwise would not study in depth, legally speaking. So what I mean, a conceptual approach is go in the direction of legal system management, and do include AI, well, potential AI-oriented solutions. And I mean, I was working with the decision support systems, expert systems, knowledge-based systems in the previous wave of AI-oriented solutions. And it's quite fascinating that quite a few of the principal issues that we discussed during the 80s are still relevant, although in a complete different context, of course. But you still quite often need to reflect upon whether there is, well, you need to reflect upon issues. Who has the right to decide, for instance, what kind of legal material should not be a base for system design? Should it, for instance, only be relevant to present the highest court decisions, or what about lower court decisions? So old school, still relevant, but today is another day. And it's quite interesting to see that we are all in the data protection community struggling with the different concepts and of explainability, explainable AI also, for instance. But from a legal point of view, we try to aim for a conceptual um, description. And as a starting point, we find, generally speaking, of course, there are deviating opinions, but one could start in terms of transparency being a condition for privacy in the context of personal data processing based on AI methods. And here we have as a starting point the GDPR data protection principle regulation in Article 5. I will not burden you with too many references though. But what's more important to state is that processing governed by principles of openness, such as the Freedom of the Press Act and the principle of publicity here in Sweden, might still not provide transparency due to lack of access rights and how they are implemented or not implemented. And this follows not least from Article 25 GDPR. So this is an example of a conceptual context from a legal point of view. And then what we do, what I find interesting in the kind of work that I carry out right now, trying to broaden the perspective beyond the conventional legal methods for interpretation, is to categorize different kinds of concepts. For instance, from a formal point of view, we have the legal definitions. The legal definition is almost like a rule, but it isn't a rule, but it is this formal definition of concepts that are important, such as I mentioned in the introduction, also the regulations about whose control or personal data, consent, and there are many more concepts that are legally defined. And also we have the functional approach to GDPR. And I briefly mentioned just before that there are so many misunderstandings on how to understand anonymization versus pseudonymization, etc., and re-identification, de-identification, synthetic data, etc. And once again, we as lawyers, we find ourselves in this sea of different concepts and this steering concepts, the algorithms that challenge the rule of law when legal texts of different kinds are digitalized and programmed into software solutions. And definitely not last and not least, we have topical concepts, and information security and is entering the legal scene indeed. There used to be quite a divide, I would say, between data protection discussions on the one hand and information security on the other in the data protection environment. But we see much more right now of bridging gaps and information security entering into the legal scene. But be careful, because there are such fundamental security concepts such as confidentiality, integrity and availability. We have non-repudiation, traceability, etc., that may have an understanding or an explanation, interpretation, description, integrity, for instance. Integrity, not integrity, correct data. A lawyer will primarily understand integrity in terms of privacy. Confidentiality, does that imply contractual confidentiality or a legislative one? Once again, we see a cluster of concepts emerging. And also from a historical point of view, who cares about legacy data and legacy applications? But the spaghetti metaphor is still valid in terms of too many systems, not well, the infrastructure is fuzzy, and there is every reason also from a legal point of view to approach legacy data. I will wrap up by just mentioning briefly 3 different kinds of applications that shows why it's important from a legal point of view to dig into what seems to be very high up on the agenda. Well, one example has to do with data minimization. Data minimization being a data protection principle. What we see here in Sweden, though, is that the starting point for our national legislation on archives is the opposite. Every official document is supposed to be kept forever until the next ice age. So we have, and if you add AI to the picture, you realize that it becomes even more delicate how to relate to data minimization as a data protection principle when there is national legislation moving the complete other direction. Furthermore, we have a way, I mentioned previously, we have the Freedom of the Press Act, the principle of openness, which comprises compilations of data, could very well be personal data, as long as it only requires routine measures. Routine measures is an expression that actually is found in the Freedom of the Press Act from 1766, not that they actually enacted in those words, but it's one of our fundamental laws. Routine measures being defined in the preparatory works as a simplistic procedure without any particular costs and other complications on behalf of the public agency. And just if you add AI to this concept, you realize that what's a simplistic, simple approach today definitely might be something different tomorrow. So here again, we have the impact of what do we have? I'm sorry, where you have the impact of concepts, yes. And then my third and final example has to do with technical interpreters. If we take a brief look in the Administrative Procedures Act in Sweden, we can see that there are quite a lot of burdening rights on behalf of the agency, but rights on behalf of individuals when it comes to having a right to interpreters to understand administrative procedures. Maybe, or it could be discussed, argued that we need some what may be referred to as digital technical interpreters that explaining the logic behind certain technical solutions. So that's just another way of using concepts as a tool for discussions about the development of digitalization and the rule of law, rights on behalf of individuals. And here's some more information about the DataLEASH project. And I think that was what I had prepared to bring up today. And in conclusion, then there will continuously be an interplay between law and IT. I mean, there is no doubt about that. So thank you for listening to me.